Hello, everyone, and welcome to Uncivil Law. For today's case, we have Manny Pacquiao versus Mayweather boxing match pay-per-view litigation. In this case, for the Ninth Circuit Court of Appeals, a bunch of people who bought tickets to the Pacquiao-Mayweather boxing match, both pay-per-view and live tickets, sued because Pacquiao hid a condition where he was injured, but he hid that condition from people. And so the claim is that people bought the ticket under false pretenses. So a bunch of people sued a whole bunch of other people because they did not get the boxing match they wished. So we're going to cover this case and see what happened and see what the Court of Appeals says is, can you be sad if you did not get the boxing match you desired? Let's see what the Court of Appeals has to say. So before we get into the merits of the case, I just want you to see how many cases are actually involved in this, because a whole bunch of cases were actually consolidated. This isn't one lawsuit. Oh, no. It's a whole bunch of lawsuits. Every one of these numbers here on the right represents a different lawsuit that were consolidated into one case. So do we even want to count how many numbers there are there? Because it goes on for 2 pages. So that's like, I don't know, 30 separate lawsuits that this represents. So when it talks about Manny Pacquiao Mayweather, we're talking about 30 separate lawsuits that are being decided at one time. Super duper exciting. So when I said everyone sued everyone else, I wasn't kidding. Let's carry on with the substance. Pacquiao and Mayweather squared off at the MGM Grand Garden Arena in Las Vegas on May the 2nd, 2015. After 12 rounds, Mayweather was declared the winner against the underdog Pacquiao in a unanimous decision. During the post-fight press conference, Pacquiao revealed that he had injured his right shoulder in training camp nearly a month before. Plaintiff in numerous jurisdictions seized on the injury disclosure and filed putative class action complaints alleging that Pacquiao was damaged goods. That the fight was a magnificent con, and they would not have purchased tickets had they known of Pacquiao's injury. The district court dismissed the complaints in this multi-district litigation on the ground that plaintiffs have not suffered a cognizable legal industry because, in short, they got what they paid for. We affirm. For several years before the long-awaited May 2nd, 2015 fight, Pacquiao, an 8-division world champion, and Mayweather, an undefeated 5-division world champion, were considered and reported to be the best, pound-for-pound, fighters in recent history, if not ever, in the world. On or about April the 4th, 2015, Pacquiao tore the rotator cuff in his right shoulder during a sparring session. As a result, Pacquiao had to discontinue sparring sessions during his training camp and sent one of his sparring partners home with instructions not to disclose the injury to anyone. Despite the injury, Pacquiao's head trainer, Freddie Roach, remarked to media outlets that he had never seen Pacquiao in such pristine condition. Roach boasted that Pacquiao was in top condition and called him a freak. Pacquiao's promotional company publicly declared that Pacquiao is better than I've ever seen him. He's super confident and super relaxed, and you're going to see the best Manny. Pacquiao was training with only his left arm in order to sharpen the use of his deadly left punch, and to help him improve his footwork so he could cut off the ring against the elusive Mayweather. He also stated that Pacquiao could beat Mayweather with his right arm tied behind his back. And during a press conference, Roach stated that Pacquiao is in great shape, had a great training camp, and that he's ready to go. Pacquiao also said during this press conference that he's feeling good, very good. So the scene is set. Pacquiao and his trainers are saying that he's in very, very good condition, the best condition ever, that he can fight this guy one-handed, but all this time he had an injury that was undisclosed. So the question is from these people, does that affect the reasonable part of the bargain? Let's go on to see why they're so grumpy. Tickets to the fight went on sale on April the 23rd, 2015, and sold out within minutes, commanding prices ranging from $1,500 to more than $7,500 per seat. On the secondary market, single tickets sold for as much as $231,000. $231,000 for one single ticket. I think probably under any circumstances, that's a bit much, but that's just me. Pay-per-view access to the fight broke the record for the most expensive boxing pay-per-view event in history, with commercial subscribers paying up to $10,000 to show the fight at their establishments. On May the 1st, 2015, the day before the fight, Pacquiao and Pacquiao's personal advisor completed a form under the penalty of perjury. Pacquiao represented on the questionnaire that he had not suffered any injury or serious medical condition of any kind. What liability Pacquiao has to the Nevada State Athletic Commission or to the state of Nevada for his false statements under perjury are, of course, a separate issue that is not raised here. 3 hours before the fight, however, a top-rank employee informed the commission for the first time of Pacquiao's shoulder injury and asked that Pacquiao be allowed to receive a pre-fight injection of an anti-inflammatory pain medication. The commission denied the treatment request because Pacquiao had not disclosed the injury on his questionnaire or in an otherwise timely manner. Ultimately, physicians medically cleared Pacquiao to enter the ring. After 12 rounds, each of 3 judges declared Pacquiao the winner of between 2 and 4 rounds, and Mayweather the overall winner of the match by a unanimous decision. According to the Los Angeles Times, the fight was a yawner involving damaged goods. After the fight, Pacquiao, Arum, and Roach all stated publicly, for the first time, they had known of Pacquiao's shoulder injury for at least 2 weeks. Pacquiao also stated that he was not really 100% during the fight as a result of the injury. Pacquiao and Top Rank issued a statement on a website confirming Pacquiao had suffered an injury to his right shoulder but had decided to proceed with the fight with advice of his doctors. Pacquiao alleged defendants knew of the injury before the fight. In addition to Pacquiao's camp, the Mayweather defendants allegedly knew because they had a mole in Pacquiao's training camp, and HBO knew, or should have known, because it produced a documentary, Mayweather Pacquiao at Last, which followed Pacquiao's training leading up to the fight. Yes, they are literally suing because it's boring. That is what's happening, yes. They claim they would not have purchased their tickets, pay-per-view, or closed-circuit distribution packages if defendants had not made misleading statements relating to or omitted material information regarding Pacquiao's physical condition. Plaintiffs contend the public would naturally believe, as they've been led to believe, they are purchasing the right to see a contest between highly conditioned, healthy athletes in peak physical condition and not suffer any form of disability or serious injury. Now we're going to briefly get into the procedural history where we talk about how many people were butthurt that the fight was not what they hoped it would be. Plaintiffs filed putative class actions complaints in numerous jurisdictions against Pacquiao defendants, Mayweather defendants, and HBO. The United States Judicial Panel on Multi-District Litigation created a multi-district litigation and issued a transfer order under 28 U.S.C. 1407 to centralize proceedings in the Central District of California. So if you're ever wondering how multiple lawsuits filed in multiple places dealing with the same matter are dealt with, this is one of the ways they're dealt with. There is a panel on multi-district litigation. So if a lot of people are suing in a lot of different places over essentially the same thing, the federal government has a way to solve this problem. They consolidate in one place to deal with all the problems. Makes sense. So they centralize this in Central District of California. Fine. The district court accepted these complaints as filed on July the 7th, 2016. At the time the district court ruled on the motion to dismiss, the multi-district litigation consisted of 26 individual actions, 13 jurisdiction-specific complaints filed on behalf of putative classes of pay-per-view purchasers, a single complaint filed on behalf of a nationwide putative class of ticket holders, and a single complaint filed on behalf of a nationwide putative class including California and New York subclasses of commercial entities that purchased the closed-circuit distribution rights to televise the fight. So very many people were butthurt. On August the 25th, the district court dismissed all the complaints with prejudice. The district court held the plaintiffs had suffered no legally cognizable injury. With the factual predicate out of the way, the court is now going to discuss the law and what law applies to this kind of claims. A majority of courts that have considered claims brought by dissatisfied sports fans follows what's known as the license approach. Under that approach, a ticket holder enjoys the right only to view a ticketed event and therefore no cognizable injury arises simply because the event did not meet expectations. You purchased a ticket to see what happened. Whatever happened, happened. You got what you paid for. Go away. In Bowers versus Fédération Internationale d'Automobile, the Seventh Circuit said, analyzing the plaintiff's breach of contract claim, the court observed most states agree the seller's contract only to admit the plaintiff to its property at a given time, not to provide a particular spectacle. Thus, the seller agrees only to license the plaintiff to enter and view whatever happens. While every competitive sport is built around the presumption that players will try hard to win, a contest is not invalidated by a player's poor effort. A team cannot claim a loss does not count because one of its members was dogging it. And once it's established that the plaintiff received a regulation race, they admit they had no additional right to a race that was exciting or that the drivers competed well. You get to watch what happened. That's it. Go away. Similarly, in Mayer versus Belichick, the Third Circuit affirmed the dismissal of a putative class action brought by a season ticket holder against the New England Patriots in response to a scandal known as Spygate. Belichick enters the mix. The plaintiff asserted contract and tort claims, including fraud, alleging during a game against the New York Jets, the Patriots surreptitiously videotaped their opponent's sideline signals to use that information to their strategic advantage later in the season. This conduct allegedly violated the rights of New York Jets ticket holders, who fully anticipated and contracted for tickets to observe honest matches played in compliance with all laws, regulations, and rules. The Third Circuit held that plaintiff possessed either a license or, at best, contractual right to enter Giant Stadium and to have a seat from which to watch a professional football game, but nothing more. Here, plaintiffs undeniably saw football games played by two NFL teams. That's all you were promised. Got what you were promised. Sorry, it wasn't what you were hoping for. Most state courts have adopted a similar approach. Most recently, the Louisiana Supreme Court held in Le Mans versus National Football League that season ticket holders have no right of action to challenge a referee's missed call during a 2019 NFC Championship game between the New Orleans Saints and Los Angeles Rams. Some sports fans out there take things pretty seriously. Lawsuits over a referee's mixed call? Okay. Plaintiffs acknowledge the weight of authority against them. Yeah, just a little bit. But characterize themselves as defrauded consumers. Turning now to this case, we first address plaintiffs' argument that, like season ticket holders in Carpenter and Bidder, they have alleged a cognizable claim because they would not have purchased tickets for the fight but for the misrepresentations. We do not find the season ticket holders to have much persuasive value here. Importantly, the claims asserted in those cases were not premised on the athletic performance ability on the track, in the field, or on the ring. In the prior case that is alluded to, season ticket holders bought tickets to particular matches at a particular venue, but the team moved. So that was the breach of contract because they didn't even get the fight. Because they didn't even get the football match that they were promised because the team moved. So that was the breach of contract there because the season ticket holders did not get the value of their full season. Plaintiffs in this case paid to see a boxing match between two of the top fighters in the world, Mayweather and Pacquiao. Each was medically cleared to fight by the association physicians before they entered the ring. Ultimately, a 3-judge panel declared Mayweather the overall winner of the match, but each of the judges decided that Pacquiao was the winner in between 2 and 4 of the rounds. And although the match may have lacked the drama worthy of the pre-fight hype, Pacquiao's shoulder condition did not prevent him from going the full 12 rounds, the maximum number permitted for professional boxing contests. Even though the license approach may not map perfectly onto allegations in this case, we need not adopt that approach to conclude that plaintiff suffered no legally cognizable injury here. Whatever subjective expectations plaintiff had before the match did not negate the very real possibility that the match would not, for one reason or another, live up to those expectations. If you're going to spend $231,000 on a single ticket rather than, for example, a home, you might have to factor in the fact that the match may not be everything you were hoping for. Although I stretch to understand what you were even in theory hoping for to justify a $231,000 purchase price, but who am I to judge such things, I guess? We find unpersuasive plaintiffs' remaining arguments that their claims are no different than claims alleging fraudulent inducement to procure, sale, or other goods or services. In a typical consumer protection case, consumers form beliefs about what they can expect by relying on public representations regarding features of the good or service at issue. These principles do not apply with equal force to claims brought by fans in a sports context. A sports match or game, unlike a consumer good or service, is defined only by a set of rules that are well known to fans. The rest is determined how well the match is fought or the game is played. So the court here is saying this is not like you buying a car, being told it had a sunroof, and it didn't. When you buy the car and it doesn't have a sunroof and you were told it did, that is consumer protection. But here, what you were told is there is a match that's going to occur on this date. The match did occur on this date. So that's basically the end of that. We also note in seeking to hold defendants liable for alleged omissions and misrepresentations regarding Pacquiao's physical condition, plaintiff's theory of liability is potentially boundless. The nature of competitive sports is such that athletes commonly compete and sometimes dramatically win, despite degrees of physical pain and injury. Plaintiff's theory of liability also presents serious workability problems. Would athletes be required to make affirmative disclosure regarding any discomfort they felt, or only with respect to a diagnosed injury? Would it matter whether the diagnosed injury caused an athlete no pain? And how far in advance of a game or match would such a disclosure be required? Like the racing fans in Bowers, who saw only 6 out of 20 cars that were expected to race, or of the boxing fans in Castillo who witnessed Tyson shamefully disqualifying by biting off of part of his opponent's ear, plaintiffs here have no cognizable claim amounting out of their performance by Pacquiao that fell short of viewers' expectations. The district court was therefore correct to knock out plaintiffs' complaints. Knocked out? Yeah? Okay. So that is the end of the case of In re Pacquiao Mayweather boxing match pay-per-view litigation. In this case, we learned that a bunch of people who bought tickets to the Pacquiao Mayweather fight, both pay-per-view and live, who spent up to $231,000 for their ticket, like that wasn't a bad idea in the first place, sued because the match was not all they hoped for. Pacquiao somewhat misrepresented his health condition. But as to the sports issue, you bought a license to the event. You bought a ticket. You didn't know what was going to happen. Someone could have knocked someone out in the first 5 seconds. I've seen that happen in MMA, or, a whole bunch of other things could have happened. So you were not guaranteed any kind of particular fight, just that a fight would happen. The fight in fact did happen, so you got exactly what you bargained for. Sorry you're salty, but there's no claim of relief. Go away. 26 people who sued in this case. So that is the end of this case.